I too would like to start by acknowledging the Gadigal people of the Eora Nation as the traditional custodians of the lands here in Sydney on which we're meeting, and the Wurundjeri people of the Kulin Nation in respect of our colleagues in Melbourne. I pay my respects to them and their culture and their elders, past, present and emerging, and acknowledge their continuing connection to land, sea and their communities. I also want to acknowledge and pay my respects to Aboriginal people who are joining us in this meeting today. I'm delighted to be here at this annual conference of the Media and Communications Law Committee. I've probably been practicing close to 40 years, and a reasonable number of those years in private practice had quite a bit to do with media and communications. This is a critical time for media and communications lawyers, whether within regulators or in private practice, to discuss regulatory reform and the value of an agile, flexible regulatory regime for addressing problems that arise in digital platform markets. Why is it at a critical time? I think there are three key points that signal that. Firstly, international legal developments tell us the time is nigh and we should be moving. The second is that the scourge of scams will continue to defeat us, and by that I mean all of us with a strong commitment to legitimate, lawful business behaviour, and both in the private practice and in regulators, unless we have comprehensive, well able to be enforced consumer protections. And for that area that is enticing people, whether involved in digital platforms, whether users or whether regulators, the challenges posed by generative AI could be flexibly addressed only as needed by such a regime. So just looking at the most recent international developments, which we are watching closely, and I'm sure you are too, particularly notable ones in the last few months. So perhaps you are all following what, as the team at the ACCC are, what is coming out in evidence in the US Department of Justice case against Google in relation to the allegations concerning the dominance of its search engine and apps by engaging in a range of anti-competitive and exclusionary conduct as alleged over a period of 15 years. That case has been described, probably correctly, looking at both the allegations and the remedies sought, as the biggest antitrust case in a generation. Secondly, closer to home, the Japanese headquarters for digital market competition, so a group of the government ministry published its report on competition in mobile ecosystems in June. That report set out two possible options for addressing the identified competition issues that the HDMC considered are already existing and that existing competition laws were unlikely to address. And it looked at regulatory change either as outright ex-ante regulation or co-regulation. All of us will know the European Commission has designated 6 digital platforms, Alphabet, Meta, Amazon, Apple, Microsoft and ByteDance, owner of TikTok, as gatekeepers under the Digital Markets Act. There will be 6 months, probably actually a bit less than 6 months now, before the provisions and prohibitions will commence, and therefore either there will need to be a change in business practices, legal challenges, or enforcement by the DG Comp in respect of the obligations under the DMA. There have also been notable developments at a regulatory level. Later on, I'll talk about the business developments related to AI. In June, the US Senate Majority Leader, not the House one, who lost his leadership, the speakership this morning, released a legislative framework for AI, and in September, the US Senate began holding the first hearings as part of its AI Insight Forum. In July, the UK launched a parliamentary inquiry into large language models to explore a 1 to 3 year plan for the UK to respond to their opportunities and risks. In August, the Spanish government announced it had created an agency, which may be the first such agency for supervision of AI, the EU's certainly first AI regulatory body. In September, the UK CMA published its review of AI foundational models, highlighting a range of competition and consumer issues that the ACCC had been discussing with the CMA together for some time. Also in September, the G7 ministers agreed to develop a set of artificial intelligence guiding principles and a code of conduct for organisations developing advanced AI systems. Here in Australia, everybody in this room knows well the digital platform services are crucial to how we connect, make purchases, work and study. Australians spend almost 6 hours a day online. 92% of us own a smartphone. We use it for around 5 hours a day, and 80% of us are social media users, averaging 2 hours a day. That is a combination of for work purposes, for transactional purposes, for entertainment, information and connection, communications purposes. Many businesses are depending on these services. For example, to access new customers and to maintain contact with existing customers. So in 2021, 82% of Australian SMEs used Facebook apps to help start their business. It's on the basis of Facebook's own surveys of their customers and of potential customers. In just 1 month, September 2022, up to 200,000 Australian businesses advertised on Facebook or Instagram. We are all aware that Google, Apple, Meta and Microsoft each have global revenues of over $100 billion, dwarfing even the largest Australian companies. And indeed, the market values of Apple and Microsoft in 2023 exceeded our country's GDP, measured in 2022. The largest platforms continue to expand their ecosystems of products and services, including into new markets such as financial products, education and health services. As Angela commented when I came in, we were hopeful that the government would have released our report 7 on expanding ecosystems by now. However, we can all just await it with excitement. To encourage platforms to provide, because we did deliver it to them over a month ago, to encourage platforms to provide high quality and innovative services at market prices. The ACCC is advocating, and has been since our September report last year, for a capacity to have targeted service-specific codes in relation to solely the most influential platforms, only in relation to the services where there is such a high degree of influence and limited competition that it's appropriate for those services to be regulated. To provide effective competition, the benefits for Australian small businesses that are selling, transacting, marketing on those platforms, and stronger safeguards for consumers. In the time since 2017 that the ACCC has been looking at these platforms, it has identified areas of important competition issues, resulting in, we consider, reduced choice, reduced quality and higher monetary and non-monetary prices, the greater use, capture and use of data, greater proportions of time spent receiving and trying to click away unwanted ads on your phone, in digital platform services. We've also seen rising levels of scams, the proliferation of fake accounts and fake reviews. And fake accounts as a source not only of fake reviews, but then of scam activity and bad actors, and a lack of effective dispute resolution harming consumers. In our 5th report, as you will be aware, we proposed reforms to better promote competition and protect consumers in digital platform markets. I want to take a brief amount of time to explain, because it's very relevant for lawyers, and some of it I know lawyers in this room will contest, why we consider these reforms are necessary as a companion to the existing competition and consumer protection laws under the CCA. We consider those are robust and important laws, but by themselves insufficient to address the harms arising from digital platforms. Our first reason is that investigation and enforcement action under competition law is particularly lengthy, resource intensive, and may not provide timely or effective outcomes that respond to fast moving digital platform markets and would bring them to a more competitive state into the future, preventing future harm. So many of us will be aware that it took more than a decade for a decision on the ACCC's action against 15 international airlines for price fixing arrangements. And I know that has included multiple appeals. However, even at the core initial trial, it took a substantial period of time to get the initial judgment. The European Commission's Google Android case took 7 years to achieve their over $4 billion euro fine against Google for imposing anti-competitive contractual restrictions on mobile device manufacturers and MNOs. The Epic Games proceedings under 46 were instituted against Apple in 2020, Google in 2021, here in Australia over in-app payment requirements in the app stores, and those cases will not come to trial until March next year. Even at the point at which there is successful litigation, and of course that is always a risk and not necessarily the outcome until the judgment is given, it is not in the nature of a court judgment to be able to address the widespread impacts of harmful conduct. So court processes necessarily focus on specific instances of conduct supported by specific evidence in relation to specific weaknesses and specific harms. It will be confined to compensation and remedies for past harm. Of course, there can be declaratory relief not to engage in such conduct in the future, but it will not address underlying elements of market power and behaviour into the future. Experience has also demonstrated that even when platforms are required by one jurisdiction, either because of legislative reform or because of a successful enforcement case, that they don't then always fully implement those remedies in other jurisdictions. The example of third-party payment tying the third-party payment services within apps. There has been change, for example, by Apple in South Korea for all apps after the legislative reform, though I know there is a contest as to how much benefit that has produced. And in the Netherlands for dating apps only, following the Netherlands agency's enforcement action, but not occurring apart from consideration in the UK in relation to the CMA's intention to accept binding commitments offered by Google to allow alternative billing options for in-app payments. These changes have not been rolled out, either in some cases at all or otherwise in full in Australia. Finally, it is also the case that digital platforms operate and the services operate in a complex way. There are complex global corporate structures, complex sets of contracts that sit behind the arrangements both globally and within jurisdiction, complex technological aspects, and then complex behaviours, which can make it difficult to detect unlawful conduct. This is why the ACCC has recommended new competition rules for the most influential digital platforms to stop harms to consumers and competition before they occur, and to set the framework only in relation to a very small set of the most influential platforms and specific services, so that it sets the basis for more competition and better consumer protection. The manner of elements that the ACCC has looked to in terms of concerns as to anti-competitive practices have included ones well known to the many competition lawyers in this audience, so self-preferencing exclusivity agreements, impeding switching, denying or impeding interoperability, and withholding access to important hardware, APIs and data inputs. It is reasonable, and probably George will address these questions, to ask what makes digital platform services different from other types of firms. We know that that question is often posed to us. The ACCC's view is that there is a unique combination here of economic characteristics, each of which will be observed in other sectors and some of which are observed in combination, but is of some of them, but not that there is the combination of all in such a rapid, dynamic combination. So the characteristics include network effects, significant economies of scale, advantages of scope and the incentive to expand ecosystems, to continue to lock in increasing user numbers with increasing then incentive and dependence upon the services that they have across the multiple services in the ecosystem, and of course, access to large quantities, in effect the corpus in some ways that is available on the internet, large quantities of high quality user data. The government has conducted a public consultation on the recommendations, and we await with hope the government's response to those recommendations. However, we are hopeful that that will transpire relatively soon. We have recommended, in addition, a range of measures to address harms to small businesses and consumers on digital platforms. You will be aware we reiterated support for economy-wide reforms, such as the current SISON process in relation to unfair trading practices. In addition, we recommended specific mandatory obligations on all digital platforms to address scams, harmful apps and fake reviews, and to improve dispute resolution processes. These protections are essential to address increasing levels of scams and fake reviews, which have led to growing financial and non-financial harms, as well as the lack of effective dispute resolution for consumers when problems arise. So in 2022, on the ACCC and now NASC Scam Watch service, Australians reported losses of over $80 million to scams on social media, up from losses of $56 million in 2021 and $27 million in 2020, and we know scams are greatly underreported. Scammers can target potential victims using fake accounts, and the inflation of user numbers and post views using fake accounts can make it difficult to identify scam conduct. To address these issues, we've addressed and recommended targeted obligations on digital platforms, which will be in common with those being developed together with the ACMA and ASIC in relation to telcos and companion ones with banks. But in relation to digital platforms, notice and action requirements to address scams and harmful apps, and stronger verification of business users, particularly those coming onto the platform to advertise financial products and financial services. We've also recommended mandatory internal dispute resolution standards and the introduction of an external Lombard scheme to deal with unresolved disputes. These recommendations complement the work of the new National Anti-Scam Centre. The objective in relation to the centre, which has been moving rapidly since the launch in 1 July, is to make Australia the world's hardest target for scammers. It's a very lofty goal. We do, however, recognise that as scammers are international criminal networks, the question of where there are the most impediments and the most difficulty of receiving bang for their investment in their ability to intercede, basically, and to populate Australian telecommunications services and digital platform services is an important part of their equation as to where to spend their money and their resources. So we're seeking to bring together regulatory and private sector and across government and law enforcement expertise and resources to disrupt scams, raise consumer awareness about how to avoid scams in consistent and clear and timely ways, and to link scam victims to services where they have lost money or had their identity compromised. The ACMA, the ACCC and ASIC together form the Scams Regulator Steering Group, and we have had now 2 very valuable meetings discussing both our objectives and the ways in which that we can take this forward together. For the next 6 months, an investment scam fusion cell, I still pause at that term. I think it's a time-limited working group, getting away from the jargon of it, with representatives from digital platforms as well as banks and the telcos to disrupt investment scams and minimise losses for Australians. It will be the first of a series of such time-limited working groups that the NASC will coordinate, which will each target specific scam types. This work will be greatly assisted by the establishment of whole of ecosystem obligations, and by that the ACCC, ACMA and ASIC intend that to be mandatory ecosystem obligations and industry-specific enforceable codes with clear requirements for businesses to take steps against scams. Just looking at the topic that's highly relevant to our work in many areas across the DP regulators, including to our work on scams, which is generative AI. It's manifest that the increasing range of products and services powered by generative AI have the potential to benefit consumers and increase productivity and serve regulatory ends, actually. However, as regulators, our job is to think about those opportunities and where they can benefit regulatory ends and objectives, but also to be aware of emerging risks. As was noted in the joint DP Reg submission to the DISA Safe and Responsible AI in Australia discussion paper, these may include risks for competition and consumers. These new technologies are manifestly driving innovation, and the popularisation and mass market access to generative AI may provide an opportunity to challenge the market position of currently very strong dominant platforms. However, the integration of generative AI into the services of digital platforms also has the potential to raise many of the same barriers to entry and expansion that we have seen to date. We can see that existing larger digital platforms likely have a head start in developing and deploying high-quality generative AI services due to the importance of access to a broad set of data from which to learn and computing power, massive computing power. In the past week, Meta at its annual Connect event revealed its extensive AI offering, both in existing apps, but also in a whole set of service-specific apps, and as may be applied in the virtual reality headsets. So it is joining the generative AI offerings of Google and Microsoft, each of which are integrating these large language capabilities both into existing apps and new products. That is joining other smaller participants and newer participants, but you can see the way in which the integration works well in the expanding ecosystems of the largest digital platforms. We are aware that generative AI systems could also enable such platforms to further entrench and extend their market power by leveraging substantial user bases and engaging in more effective and potentially difficult to detect forms of anti-competitive conduct, such as anti-competitive self-preferencing. We can see that new service-specific codes, or the ability for them to be introduced, could assist to address specific conduct where there have been observed concerns in this regard involving generative AI that risks harming competition in existing digital platform markets. In terms of consumer protection, in some respects, generative AI has the capacity to help in the fight against scams, such as by helping to identify and disrupt likely scam calls more quickly and effectively. However, the technology may also bring about new risks to consumers or exacerbate existing risks. We could see greater volumes of more sophisticated scams that are better targeted across digital platforms, phone and SMS, whether in terms of virtual voice, replicative virtual voice, whether in terms of the use of generative AI to create large volumes of much more credible fake reviews that use language that much more speaks to the local population and potentially even is capable of using data personalised to individuals to accord with the way those individuals are thinking and would speak. So that can undermine consumer choice and ultimately distort competition. The consumer reforms that have been proposed as part of the DPSI we consider would complement the role of the NASC in helping to combat AI-assisted scam activity. So I've already noted that our upcoming 7th DPSI report we hope will be issued soon, and our 8th report looking at third-party data broker services will be released next year. That will leave only 2 more reports in the 5-year, 6-monthly digital platform services inquiry. All have brought to light important aspects of the way the services are provided and the potential areas of consumer concern and competition concern I'm looking forward to Karina's presentation and then to the panel with colleagues. Thank you very much.
Thank you. Thank you, Angela. I would also like to begin by acknowledging the First Nations peoples as the traditional owners and custodians of Australia. I respect and celebrate First Nations people as the original storytellers and content creators of the lands on which we meet. And I honour the enduring strength and commitment of Aboriginal and Torres Strait Islander peoples to the lands, waters and their communities. I pay my respects to their elders past, present and emerging. Thank you for inviting me to speak today, and I'm very pleased to join my colleague Gina Cascott-Leeb here today. I was actually a client of Gina's nearly 25 years ago, so that shows how long we go back. That was in my PBL days. So in the 5 years since I started at the ACMA, 5.5 years now, our role as a communications and media authority has completely transformed. It's a totally different organisation. Digital platforms and online services more generally are our day-to-day work now. I'd like to talk about 3 areas today, particularly largely because they relate to digital platforms, but also because I think they draw out the different regulatory models that we look at and which are quite good for discussion. I mean, an increasing part of our work is minimising online gambling harm. The second one I'll talk about is enforcing rules that require telcos to identify, trace and block scams, calls and texts, which Gina's already referred to. And lastly, the controversial one that we oversee the digital platform industry's efforts to combat seriously harmful misinformation and disinformation. So I'll talk about these in a minute, but first just a couple of comments generally about digital platforms, which Gina has very well drawn out as well, I think. So it feels like they've been with us forever. We've always known that Facebook, Instagram and Twitter, now X, feel like they're old friends. But from a regulatory perspective, that's not really true. They are still relatively new. Initially, just like with the online regulation probably 20 years ago, the first leaning was to very light or no regulation at all to ensure that the benefits were of innovation were not stifled. But as we've seen, this has rapidly changed and there's a steadily increasing impetus for regulation. But as we know, there's no one size fits all. We do need to accommodate different regulatory models to the different types of services that we have in front of us. And I think one of the challenges that's really coming out in a regulatory and a legal sense now for regulators and decision makers is, that definition of digital platforms is one that's loosely used, but when you actually start to drafting regulation and legislation, it's increasingly difficult. If you speak to someone in the EU, it often just means social media. They're fairly loose in their terminology. I was interested, I went back to the initial comment that the ACCC made in its report, the first one, and it's quite a good definition, but we've grown beyond it, as Gina has said, which is services built to attract consumers to the platform and then sell access to these consumers to advertisers. And that was right. But as we know, it's moved on. We're now talking, sometimes people talk about it's a service that has the ability to spread information and behaviour virally, and that's equally applicable. But it also refers to dating apps, particularly when you start talking to the e-safety and referral services. Whatever it is, it's definitely evolving. And then, of course, is the issue about when you're looking at it from a competition point of view and you're looking at it from a harms point of view, it can be quite different. At times, ACCC is looking at alphabet, and then, of course, from a harms point of view, and this again is an issue that the e-safety has been confronting, you're looking very much at the services. It's been a challenge for e-safety, it's a challenge for us, it's a challenge in the code for dis and misinformation, it's a definite challenge in the draft legislation, and increasingly that will become an issue in relation to scams. And the other point is that increasingly the regulatory line between a digital platform and other online services is starting to become less relevant, and we certainly experience that at the ACMA. But it all highlights that you need to have evidence-based and you need to have real facts behind you when you start to develop regulatory activities. Now, it's a pretty obvious statement. We all know that digital platforms are ubiquitous. In 6 months to June last year, 97% of adults used at least one communication of social media or on a website or an app. And 84% were using them for messaging, voice or video calls. And clearly they contribute to they contribute to the social and economic good, but clearly there are downsides as well. And we need to look at the evidence to decide what to go further. We use an annual consumer survey, which I encourage people to have a look at. The next one will be out in December. And it looks at consumer behaviour, adoption of the attitudes towards, and how the effectiveness, the actual effectiveness of the regulatory actions we take. So as we know they're using digital platforms, but I think probably the most interesting stat to come out of that future work is that the engagement is increasing, and it's increasing markedly. If you look at figures on sharing, commenting, reacting by hitting the like button, it's increased markedly only over a period of 12 months, from some 75 to 80%. It's high, but that's quite a big increase. And our data also shows that almost 2/3, 63% of Australians can indicate they consider they've been exposed to misinformation on a digital platform. Now, I find that statistic somewhat tricky because it's very personal. One person's misinformation is another person's fake news. So I do treat that with somewhat a grain of salt. But importantly, we complement all of this with intelligence, namely from the experts around us. We're not too ashamed to tap in on everybody else. We're keenly engaged and looking at the European Union's experience in the Digital Services Act at the moment, and how they're going to impose the obligations on FLOPs. I think there's some real challenges in the Union, and they are certainly tackling that at the moment. We're looking closely at the UK's proposed online safety bill, looking at possibly a single regulator into the Ofcom to deal with harms, and work with other regulators, particularly Canada, Ireland, European Union itself, the countries within the European Union, United Kingdom obviously, and the Netherlands. And as Gina said, international cooperation in this space is amazingly important, and very important given that it is an industry that's full of players who are almost all of them, not quite, but almost all of them are based outside Australia, and they're all operating in multiple jurisdictions across borders. And closer to home, of course, we have the collaboration between the 4 specialist and experienced regulators who have formed the Digital Platforms Regulators Forum, which I think we'll talk a bit more about later. I think it's pretty remarkable having 4 regulators appear in front of a Senate committee. I'm not sure if that's been done at all, if it has, certainly not recently. So first I'm going to talk a bit about our remit, which is online gambling, which seems a bit off the topic in relation to digital platforms, but not really. We know that online gambling has more than doubled in the last 8 years, from 8% to 7.5% of the Australian adult population. But interestingly, what we also know is that the rate of problem gambling amongst online gamblers is 3 times the rate it is amongst people that only use land-based gambling operations. And our rapidly growing role in this area is connected to 3 areas. The first one is that we're responsible for BetStop, the National Self-Exclusionary Register. I have to give it the whole name because it's trademarked. I'm not allowed to just say BetStop, which is a service to enable individuals to self-exclude themselves from all gambling operations and advertising and promotions for a minimum of 3 months up to a lifetime. We secondly, under the Interactive Gambling Act, enforce the prohibition of illegal interactive gambling services such as online casino games and online unlicensed wagering service, which has been somewhat successful. It's a very tricky area to work in, but our stats show that enforcement under the IGA has led to more than 115 services illegally removing themselves from the market, which is generally done by geo-blocking. And over the last, I think it's 3 years now, we've had more than 830 illegal websites blocked, which is an interesting issue in itself. The concept of blocking websites, if you'd said that 5 years ago, in a regulatory sense, it was horrifying, whereas now that is a reasonably accepted regulatory tool. But importantly, a key plank of this legislation is prohibiting all advertising and promotion of any illegal services where they might be, which traditionally has always been, it's usually been direct advertising online, but increasingly now we're seeing more and more involvement of digital platforms. What generally happens is that you go into a free lottery or a free poker game. Free poker game is quite a common way of doing it. You go in, you join a club, and then you're moved into illegal services. It's quite a challenge for us to trace those through. And the third area we regulate is another issue which has been quite prominent in the last year, gambling advertising on online services, on digital platforms, and also on broadcasting. Currently, it's limited to ads which are only associated with live sport, but a parliamentary committee recently has recommended that that be expanded, which the government's currently considering. And one of the key recommendations here is that over time there be a complete ban on gambling ads on digital platforms and other online services. I mean, you can see some comparisons here with tobacco, but it has some interesting parallels about how you deal with that versus alcohol, for example. Next, I'd just like to talk briefly about scams, which Gina's quite rightly talked quite a bit about, such an important issue. It's, your stats are exactly the same as mine, and that's because we got stats from the ACCC, because that's one of the great things at the moment about the cooperation that we are all doing, that we're all on the same page. I think it's interesting that there's an 80% increase in the scams reported over the last 12 months. But certainly the statistics, and I won't go into them because they're quite complex, have shown in the past that the key contact channels are very much calls and text messages. So as the sectoral regulator for the telecommunications industry, we've been focusing on this issue, but particularly we want to stop scams at the first point before they start reaching Australia. So this has led us to take 3 actions. One, we identified the need, and then we designed mobile pre-porting verification rules in 2020, which I'm sure you've all experienced. It's a bit of a nuisance, but it has been very effective in stealing identities by pre-porting people's phones for them. Secondly, we pushed, and I use that word quite deliberately, we pushed industry to develop what's now the reducing scam calls and the scam SMS code. And we also intervened with customer authentication rules, which require the telcos to use multi-factor authentication when they're doing transactions which are of a high fraud risk. So while it's very clear that reported scams are rising, and there's no doubt about that, all the statistics are very clear on that, we have seen results from these interventions, and we've seen a shift. So at a headline level, under the scam code, telcos have reported that over 1.4 billion scam calls have been blocked from reaching Australians since December 2020, and over 257 million scam texts since July 2022. You'll note that one has been in operation for a shorter period of time. So while reported scam calls have reduced by more than 60% over the last 2 years, they're becoming more sophisticated, and ScamWatch complaints data shows they're moving to other channels. They're moving more to SMS, which we have probably more work to do. The telcos have more work to do in relation to SMS, but particularly in relation to social media. And anecdotally, you know that. WhatsApp and Facebook Marketplace are 2 that are certainly seem to be high on people's concern. But importantly, these telco-directed protections don't apply to the digital platforms. So, as Gina has outlined, that will certainly be the first point of call with the new regulation when we start moving towards digital platforms and scams. And lastly, mis and disinformation, a fascinating topic. So since 2021, we've been responsible for overseeing the voluntary Australian Code of Practice on dis and misinformation. It's a principles-based code. It requires platform signatories to set out what steps they are going to take in relation to reducing seriously harmful dis and misinformation. They have to put policies and processes in place, and then they produce an annual transparency report about what they're doing, what actions they're taking to meet their code objectives and their successes. I say their successes with a bit of they don't really report their successes, but in theory they report their successes. So we've now seen 3 sets of transparency reports, and we've delivered 2 reports to government on the code. So while in each report it's been clear the signatories are undertaking efforts to tackle misinformation and disinformation, it's also clear there are considerable gaps in the data that the platforms both keep and report to us. And without keeping and reporting this Australian data, and I say pointedly Australian data, we can't make credible assessments about the effectiveness of self-regulation. And frankly, it's also just difficult to see how the platforms themselves are making those assessments and how they're communicating that with their users. So, for example, platforms are not willing to share Australian-specific information on their user complaints and feedback they're getting. And user complaints and reporting data underpin our regulatory activity in other areas, particularly in relation to the telco sector, and we feel it should be the same for the digital platforms. And we know that platforms share specific data about European Economic Area countries because they're required to do it under the new legislation, and we would like to see them do the same for Australia. But to help with these gaps, we have done some research of our own. We've particularly looked at user experiences on dealing with complaints. Our research is quite detailed, but it's showing that Australians are unhappy with how platforms are responding to the complaints. For example, those that complained to TikTok, 34%, they said nothing happened in response to that. And while 43% of complaints on Facebook were either dissatisfied or very dissatisfied with the response. And additionally, only 16% were satisfied with the platforms were transparent about how they were responding. A lack of transparency and concerns of inaction has led the government to propose its Combating Mis and Disinformation Bill. The draft bill, which is yet to be introduced into Parliament and is currently being considered by the government, would provide the ACMA with powers to require platforms to make, retain and report on records of their actions. And this would enable the ACMA, the government, academia, consumers and others to assess if self-regulation is actually working. And the bill then proposes backstop powers for the ACMA to require or impose codes or standards if it's clear self-regulation is not effective. So while the government considers the many submissions it's received, which I understand is more than 2,000, some of which are written by AI, which I think apparently is interesting and are very different from what I'm hearing, and it will consider its next steps. But in the meantime, we'll continue to work with stakeholders and particularly focusing on the reporting aspects. So I pointed out there three different, quite different regulatory models, which I think bears out the issue that the question that as businesses and services become more complex, the job of regulators and governments is to tailor the regulation to suit the particular harms, what you're trying to address, but also the services. So we had black letter law for online gambling, which is particularly appropriate given that you're addressing something that's illegal. Nearly all services are offshore, not in all, but most are offshore, and they're unlikely to comply. Then we had a combination of co-regulatory and standards for the telco industry in relation to scams. And here we're dealing with quite a different sector. It's traditionally done a lot of co-regulation and it's pretty attuned to how codes work. And the last one is self-regulation for mis and disinformation, which has the potential for graduated move towards greater regulation later. Again, it's the first stage somewhat in regulation, and arguably, as we know, there are other challenges which we confront with that regulation, particularly in relation to freedom of speech. So I think they highlight the challenges that we have in trying to frame regulations and laws appropriately for the harms we are trying to address. Thank you. I look forward to the panel.